Welcome back to Estate Planning 101. I'm attorney Thomas Burton. In today's video, we're going to discuss the 3 reasons parents of minor children need a will. So in this Estate Planning 101 series, I create these long-form educational videos to help you understand various estate planning topics. And if you watch some of my other videos, you may have seen topics on trust, avoiding probate, things like that geared towards people of all ages, but especially people in mid to later life. But today I want to discuss specifically those folks who are in the stage where you're raising minor children. And minor children means, in Wisconsin, a child under age 18. So age 18 in Wisconsin is the age of majority when you become a legal adult in the eyes of the law. And that's the age in many other US states as well. But there's special reasons, considerations, in my opinion, why parents of minor children need to think about having an estate plan in place. Specifically, at the very least, a will in place. So like I said, if you watch some of my other videos, you'll know that I talk about avoiding probate and using trust, because there's so much we can do with a revocable living trust. And they can be great tools for parents of minor children as well. But for those younger parents who have nothing at all in place and think maybe that's something I need to do only when I get older, I want to go over the 3 reasons today why I think you should have a will in place when your children are minors, just in case. And the number 1 reason is to name a guardian for minor children. So inside your will, you can name a guardian that would be responsible for raising your children, the legal guardian, if you were to pass away when they are under age 18. So again, it's going to be that age 18 while the children are under age 18. If you were to pass away, they need someone who legally can enter into contracts on their behalf and safeguard property, because a child under age 18 cannot inherit property legally, nor can they enter into contracts. And so you need someone essentially to raise the children, and this is your opportunity in the will to nominate a guardian to the court. If you don't nominate one, then it's left up to a hearing when you're gone, and a judge will decide. Now, if you have relatives, it's not always the case, but likely one of them might volunteer, but you might not want that relative to be the guardian. So your will is the opportunity to name a guardian, and I suggest naming 1 and 2, first choice, and a backup if you can. Now, if you're married, you have the benefit of the spouse, but if you both were to die in a common accident, like a plane crash or auto accident, you would both be gone. So then we need these guardians right away to take over. So in my opinion, when the children are under age 18, this is one of the primary reasons to have a will in place, to make sure your children are taken care of just in case something should ever happen to you. Now, the second reason you would want to have a will in place is you can name your own personal representative. So in many states, they use the term executor. So I'm going to write that here. But in Wisconsin, we use the term personal representative. And this is the person in charge of administering your will if you should pass away. So let's put your will up here. And this person would carry out the wishes as expressed in your will if you're gone. Now again, if you're a single parent, you want to choose someone you trust as personal representative. If you're a married couple, you often will name the spouse first. But then, again, I like to have a backup, because if you both should perish in a common accident, we need someone around to take care of the estate. Now, another thing the personal representative can do, this can be the same person, or if you choose, it can be someone else, but they can hold the property for the minors, which is your children, while they're under age 18 in what we call an UTMA account. And this is a Uniform Transfer to Minors Act. And in Wisconsin, as I said, a minor cannot inherit property. So you can leave it to them in an UTMA account, and you can hold it until age 18 or max of age 21 in the Atma account. So often, if you know someone responsible to be the personal representative, we would also name them to safeguard property for minors until they reach this age. So let's say you have 3 children and they're currently 10, 7, and 5. They're all going to reach age 18 or 21 at a different point, right? The child who's 10 has 8 years, the child who's 7 has 11, and the 5-year-old has 13. So that Atma account would last until each child reaches that age. And that's why it's important to have it in place, because you could pass away and one child's already 18, but you have 2 more who are still minors. So the person in charge of administering the will can be the same person that you name as legal guardian for the children, but it doesn't have to be the same. So sometimes you'll say, that's my brother or my sister, I want them to be the legal guardian and the executor, personal representative of my will. Other times you'll say, I want one brother to be the personal representative, he's good with the money and the finances, and I want my sister to raise the children. But whoever you choose to be guardian, you should talk it over with them first and make sure they're willing to act, because it's a big responsibility and your children are your most prized asset, in my opinion. So you want to make sure they're in good hands. So we have the personal representative to actually administer the will if you should pass away. And they would receive 2% of your estate for their services under Wisconsin statute. Now, the third reason to put a will in place is to choose your own heirs. And what I mean by that is, if you put a will in place, you get to name your heirs in the order you choose. So if you have minor children, it's likely you would want it to be your children, the heirs. Or if you're married, your spouse and then your children. But if you're a single parent, you likely want your assets to get to your children. But you may want an equal distribution, or perhaps some other distribution if a child has special needs or something like that. Or maybe you have a blended family with a second, some of your children, a new spouse, some of their children, and you want the distribution pattern to meet your wishes. That's all situations where having a will is a good idea versus leaving it to the statutes. Because if you don't have a will, it passes according to the intestate statutes, the plan the legislature has written. And sometimes these match up with your wishes and sometimes they don't. So for very simple situations, think married couple with 2 kids, it might meet your wishes, because if you pass away, you want it all to go to your spouse, and if the spouse passes, all to the children. But as your family situation gets more complicated, it isn't always how you would want to happen. And I don't know your situation, so you know who you want to receive it. But in general, the intestate statutes go to your closest living relative. And one thing I'll point out about the intestate statutes is they treat a half relative, like a half sister or brother, like a whole sister or brother. So if you come from a family with blended family, and let's say you don't have children, and your parents are gone and it goes to your siblings, it would go to half sisters and siblings the same as sibling that you share both parents with. So things like that in the intestate statutes may not be exactly how you wish. That's why it's best to make your own will, because you can name exactly how you want it to get to your children or your spouse then children, however it goes. And especially, I've seen this happen with situations where the parents were never married, but they share a child and one parent passes. It can be difficult for the surviving parent. They have to advocate on behalf of the minor child, trying to get the child part of the estate. And if there's no will in place, it becomes a lot more complicated and confusing. And finally, but with choosing your own heirs, you can say, well, what happens if a child predeceases or all my children are gone? You can name another friend, relative, or a charity, perhaps, as the backup beneficiary if, this situation happens where you're gone and the children are gone too. Let's say you all perish in a common accident, something like that. Not terribly common, but it does happen. And then in that situation, the statutes actually say the ultimate beneficiary. People ask me this sometimes, they worry about the government getting everything. Well, I looked into the statutes, followed the intestate statutes, and ultimately, if you pass away with no surviving relatives, the ultimate beneficiary is the Wisconsin School Fund. So it's not the general purpose revenue fund, but it does go to the Wisconsin School Fund if you passed away with no living relatives and no will under the intestate statutes. So instead, you could make the ultimate, beneficiary your church or charity or relative or friend you choose, something like that. So in summation, though, these are the three big reasons why I see parents of minor children should have a will in place. And I like to pair a will with a healthcare power of attorney and a financial power of attorney. And you can check out my other videos on how those documents work. But the big reasons to have the will is to protect the children just in case the worst situation should happen. And by worst, I mean if you're a married couple, both parents pass away in a common accident or shortly after each other. Or if you're a single parent, you pass away and the child or children is left under age 18. And what I have heard happening is without a will, there can be a lot of fighting amongst family, friends, or relatives over who should function in these roles. And if you've made your will and signed it in place, then that document governs and your wishes will govern after your death. So I know for parents of minor children, life is often very busy and it's not something you necessarily want to think about your own possible death. But the way I would look at this is similar to buying life insurance. The reason to buy it is hopefully you don't need it and you live a long life. But if you should pass away while the children are minors, then you have the will in place that would dictate what happens and name someone to raise the children for you. And this type of estate plan often works well from, the age you have the first child or the minor children till age 18 or 21. So you can often get 18 to 20 years out of this first estate plan if you do this type of will-based planning. And then at that point, once all the children are above age 18, you can revisit your estate plan. You likely don't need to name a guardian anymore if you're done having children, and you can either do a new will at that point or switch to a revocable trust plan or more complex planning, because often when you're raising the children, you're in that accumulation of assets stage and you just need something good in place, like I said, if the worst case situation should happen. And then later in midlife, you can revisit the plan, see how your children are doing, and maybe switch to a revocable trust plan or a new will that meets your current situation. So if you do this, you could, and it doesn't mean you can't keep your current will in place. I see people do this, that's fine as well. I'm just saying in my experience, I see people need one plan while the children are young, and then once the children are all adults, they may revisit it and put a new plan in place. But these are the three major reasons I feel parents of minor children should have, at the very least, a will in place. I hope this video was helpful to you, because the goal of these videos is to educate and inform so that you can take charge of your own estate planning. If this was helpful to you, consider giving it a like so others can see and benefit from this information as well. Thanks for watching, and we'll see you next time.